Over the coming year, I expect there to be many changes to the way USCIS processes family-based green card applications. And I think there will be many more denied applications over the coming year and many more ways in which USCIS will use technicalities to deny green card applications, slow down the process, increase general costs for immigrants who are trying to legalize their immigration status or otherwise become a permanent resident of the United States. And one of the ways that I expect USCIS will do that is by using fraudulent intent to deny green card applicants for people who entered the US on non-immigrant visas. If you're new to my channel, you might be wondering, what does any of that mean? So allow me to explain. Certain visas are considered to be non-immigrant visas. And what that means is when you enter the US on that visa, at the moment you enter, you physically enter the US in the airport, for example, you must maintain non-immigrant intent. Non-immigrant intent means you must have a plan to depart the United States after that entry. It doesn't mean that you never want to live in the US. It just means that during that trip or that entry, you have the actual intent to leave the United States. But what if you enter the US as a tourist or on a student visa and you have a US citizen fiance and you know that in a few months you want to get married and apply for permanent residence and that you're actually going to be entering as a tourist for the last time in the next few days. And you know that your next entry as a tourist is going to be your last entry as a tourist, and after that you're going to try to become a permanent resident. Well, in that exact scenario, an immigration officer might argue that you have fraudulent intent, that you didn't actually have non-immigrant intent at the moment of entry. USCIS might allege that you misrepresented your intent. Now, in reality, it's very difficult for USCIS officers to actually know what you were thinking at the moment you entered the United States. And the time when they would analyze this would be at your eventual green card interview. So this might be a year or a year and a half after you physically entered the US. And so an easy way for them to figure this out is through the 90-day rule. The 90-day rule is not a real rule or regulation. It's really an unofficial policy that was borrowed from the Department of State that basically says, if you enter as a non-immigrant or with a non-immigrant visa, and within 90 days of entering, you do something that suggests that you have immigrant intent. This could be working without authorization or submitting an actual application to permanently live in the US. What could be more indicative of your immigrant intent than literally applying to permanently live in the US? If you apply to live in the US within 90 days of entering with a tourist visa or a student visa, immigration officer might presume that you entered with fraudulent intent. That doesn't mean your green card will automatically be denied, but then the burden would shift from USCIS to you to rebut that presumption, to overcome that presumption. Let me give you an example of how this might actually play out. Let's say someone enters the US on a student visa. They've been entering as a student for the last few years. They're in their last year of college, so they've had their F1 student visa for 4 years. And they are engaged to marry their US citizen fiance. And on their most recent entry, they actually intended to just, do their course of study and then go back to their home country during summer break. Fine. But let's say circumstances change, and right after they enter, their fiance says, listen, I really want to move into this new apartment. Why don't we accelerate the timeline so that we can get married and physically live together so that our families will agree to let us live together? Why don't we just do that? We'll get a civil ceremony. We'll just get legally married. We'll apply for your green card, and then you won't have to leave the United States. And being the agreeable fiance that you are, you say, sure, that sounds good. Let's move up the timeline for getting married. Let's get married immediately. So 1 month after you enter as a student visa, you end up getting married, and then you immediately apply for your permanent residence. So less than 90 days have passed, and now you have a green card application pending. What could happen? Well, you can get to your immigration interview a year later where you and your spouse have to attend, and the immigration officer might ask you, what was your intent when you entered as a student visa? And the reason they're asking you this is because 1 month later, after saying that you're entering as a non-immigrant, as a student, you applied to permanently reside in the US. And it seems on the face of it that you may have entered with fraudulent intent. And now the government is saying the burden is on you to explain to us what your intent was at the moment of entry. And you can explain, well, I entered with the intention to just study, and my plan was to leave the United States that summer. Here's my return flight. Here is some correspondence I had with my friends and family telling them the timeline for the marriage has actually changed. Here is my email to my summer internship that I had in my home country scheduled for that summer saying plans have changed. I'm canceling it. Here is some evidence that my intent was actually to leave the United States. And the circumstances changed. My now spouse asked if we can speed up the timeline for the marriage, and there was a reason for doing that. Here is what that reason is. And basically, the immigration officer will decide whether you actually met your burden of maintaining that you had non-immigrant intent at the moment you entered the United States. If the immigration officer believes there's enough on the record based on everything you've said, everything you've submitted, everything you've done, to show that you actually had non-immigrant intent, even though you applied for a green card within 90 days of entering, you're good to go. But if the immigration officer believes that you have not met your burden of demonstrating that you entered the US with non-immigrant intent, and the reason you have to prove that burden is because you applied for the green card within 90 days of entering. Otherwise, the burden would have been on the government if you didn't take any such action within 90 days. So what is the takeaway here? Generally speaking, I would prefer it, if everything else is equal, that in this scenario, the fiancés would have waited till at least 90 days would have passed, because then when they attend the interview down the road, the immigration officer would have had the burden of proving that you didn't have non-immigrant intent instead of proving what your intent actually was. The immigration officer would have had the burden of proving that you had fraudulent intent, which is really difficult to prove. You want the burden to be on the government. You do not want the burden to shift from the government to you just because you submitted your green card application within 90 days of entering the United States. Anyway, guys, this brings us to the end of today's video. I just wanted to make a short video on this. I've made videos on this topic in the past, but we have a lot of new subscribers, and I thought that you guys might be able to benefit from this, especially since the Trump administration is clearly going to begin making things more difficult for green card applicants. I think this is an easy way for them to deny certain green card applicants. So I'm going to be making more videos on topics like these, especially for marriage-based green cards, family-based green cards, and naturalization in the coming year. I'm trying to put out several videos a week on these topics. If you're interested in these topics, be sure to subscribe. If you need any personalized assistance, you want to consult with me, or possibly hire an attorney to help you with your green card, naturalization, or deportation defense, schedule a consultation. You can find my information in the video description below. Otherwise, I'll see you guys next time for another video.